discussion on this particular theme couldn't be more timely, given the discussion over G20 policing and protests. So I'd like to welcome Stephen Keim to the.
Thanks, Greg. I also would like to acknowledge the Jagera people. Hello, Samuel. I wanted to start by giving my explanation as to why we seem to have a steadily accumulating collection of over-the-top anti-terrorism and national security laws on our books. It is not just that in the absence of a strong and effective critique of and opposition to the laws that they tend to be popular. There is something about the process of making the laws that seems to present to a government who sponsors such laws an electoral win-win situation. The process goes something like this. The government, with solemn faces, unveil a new set of over-the-top laws telling us all that the world is a dangerous place and we need these laws to protect you, the citizens. The Parliament refers the new law to a responsible parliamentary committee to report with a very short time frame that gives most people very little time to get to understand the new laws. People take a quick look at the proposals, realise some of their content and criticise them as attacking our basic liberties and human rights. The journalists who are still trying to understand the laws write a few opinion pieces which are a little critical. The government maintain their solemn, responsible faces. Then a series of responsible critics go through the laws and prepare and present their critiques. They include academics and law associations and other well-informed people. They make their submissions and give their evidence to the parliamentary committee. I have been part of this process in very recent times. No one likes to be portrayed as irresponsible. Everybody tends to concede the basic proposition that the world is a dangerous place and that it is good to protect us, the citizens. But, say the critiques, this law goes a little too far and this law needs a built-in safeguard. And sometimes this law is not really needed at all. You need to make sure that our rights as citizens are not lost in the process of protecting us. So the Parliamentary Committee reports, and it basically endorses the government's concern for our welfare, but it also endorses a small percentage of the suggestions for change, saying that citizens' rights and freedoms are very important indeed. And then the government comes back and says, of course we think citizens' rights and freedoms are extremely important, and they accept a small percentage of the Parliamentary Committee's recommendations for change. The new law is passed in almost the exact terms in which it was unveiled. It is still an over-the-top law with lots of over-the-top provisions, and yet the government gets to pass its law while saying how pleased it is to make changes because of its deep respect for the rights of its citizens. It's a win-win for the government. They get to pass the law and appear civil libertarian at the same time. Is it any wonder that they already have another law on the assembly line with another set of ways to impact on people's lives? In the absence of a strong movement to critique and oppose such legislation, the government cannot lose. I will talk about some of these new laws, but not yet. I want us to get some perspective with which to consider them. It is a time to step back. It is a time to take the long view. At times like this, perspective can be difficult to achieve, but it is of increased importance. In order to gain some perspective, I intend to share with you the results of two quite different studies from two different countries. The first of these mainly looks at events in the United Kingdom since 11 September 2001. It looks at the way in which counter-terrorism has become a field of propaganda used for political purposes. In particular, I draw on some examples where the propaganda has been grossly inaccurate and on occasion is simply untrue. The second study is the product of the combined work of Human Rights Watch in New York and the Columbia University Human Rights Institute. This study looks at the way people of a Muslim background have been investigated, prosecuted and detained in the United States since the events of 2001. It suggests that the United States government has failed to meet its human rights obligations in the investigation and prosecution of terrorism suspects and in its treatment of those in custody. So I'll start with terrorism and propaganda. The chief selling point for national security laws is that the world is awash with terrorists, any of whom could kill us in our beds at any moment. The truth appears to be that we are 4 times more likely to be killed by lightning than we are to be killed in a terrorist attack, and 25 times more likely to drown in our bathtub. And that is with most people avoiding walking in storms and having showers rather than baths. Therefore, the first way in which I wish to seek perspective is to look at the way governments have used the concept of terrorism as propaganda in the recent past. By appreciating the way in which governments have manipulated the truth for political purposes, we can learn to ask sensible and searching questions about the information that is being provided to us at any moment. It seems to be a universal fact that governments use terrorism and the need to prevent terrorism as a means of obtaining political advantage, both at home and abroad. This has led to governments creating institutions for the purpose of propagating terrorism propaganda. In a study which looks at the actions of the UK and US governments, David Miller and Rizwan Sabia, 2 UK researchers, have identified a considerable number of institutions of this kind. These include a series of coalition information centres used during the conflicts in Kosovo and Afghanistan, subsequently consolidated into the Office of Global Communications in July 2002. The Office of Global Communications, the OGC, operated under the direction of the White House and was responsible for supplying lies about the threat posed by the Saddam regime in Iraq. There were specific institutions for distributing propaganda produced by the OGC, including the Office of Public Diplomacy in the United States State Department and the Ministry of Defence and the Foreign and Commonwealth Office in the UK. In the UK, a committee known as the Iraq Communication Group was responsible for running a campaign to mislead the media on Iraq's alleged possession of weapons of mass destruction, including by providing dossiers of misinformation. Another UK propaganda institution was the Civil Contingency Secretariat, established in 2001. In a pattern becoming familiar from reading Australian newspapers at the moment, the CCS issued information to media outlets about an alleged Riken plot. As it turned out, subsequent research revealed that there was no Riken, or is that pronounced Riken, or Reason, involved, and very probably no plot. By this time, of course, it was too late. The news of the plot that did not exist had caused the broad feeling of fear for which it was intended. Another example of the misuse of anti-terrorist propaganda in the UK is illustrated by the difference between the focus of anti-terrorist policy in that country and the reality of the national security threat which actually exists. While official sources have proclaimed a severe national security threat from Islamist or jihadi violence, data obtained under the Freedom of Information legislation indicated that the major threat of political violence in the United Kingdom has been from armed groups in Northern Ireland. The information revealed that over a 4-year period to 2009, the Northern Ireland groups were responsible for nearly 2,000 failed, foiled or successful attacks, while Islamist groups had produced only 6 such attacks. So it's a very bad state we've come to when the Irish aren't worth being used in order to denigrate and say how bad they are. It says pretty bad things about Islamist people, that they're worse than the Irish in the eyes of the English. My last example from the report of the way in which official accounts must be treated with scepticism comes from Operation Volga, an actual operation against a specific alleged plot in which a house was raided and 2 brothers of Muslim heritage were arrested. One of the 2 men was shot during the operation by the police. At the time of the operation, high-profile allegations of a dangerous chemical bomb were made, with suggestions that large-scale loss of life was potentially imminent. At the time, the police denied responsibility for the shooting and made allegations that the shooting occurred when the victim tried to take the gun from an officer. Much later, the truth was revealed that the shot had been fired by the officer in error because of the bulky clothes that the officer was wearing. No bomb was found, and the two brothers were released without charge. So if I can look briefly at the Australian connection when it comes to propaganda, we know that Australian counter-terrorism police have the same capacity for elaborate show business productions. On Wednesday the 17th of September this year, 800 police officers were deployed around Sydney to raid and search 25 separate homes and arrest or detain 15 people. Their public relations staff must have comprised a significant proportion of the 800 officers, as the media were briefed with elaborate details of a plot to kidnap and behead someone in Martin Place. The police provided very many still photos of their victims, which the media were able to use in their news outlets. I think they also provided some videos. Even a photo of the beheading sword, curved and inscribed with black foreign writing, was provided. It turns out that the sword in question was made of plastic, was a common Shiite ceremonial item, and belonged to a Shiite family. Now, of course, we all know that Shiite Muslims are not the subject of the latest terrorist scare. That was 6 months ago, because the groups fighting in Iraq and Syria to overthrow existing governments are Sunni. Of the 15 people whose liberty was interfered with, one remains charged with a terrorist offence, and one has been placed on a good behaviour bond for a non-terrorism related charge involving possession of some bullets left over from a shooting trip and a taser given to him by a police friend. To my mind, the PR officers should all be given police medals. Only brave and talented officers could manage to get acres of dedicated terrorism newspaper space from a plastic sword, 3 bullets and a taser. These recent events, and those reported by Miller and Sabia, demonstrate the need for scepticism when the counter-terrorist publicity machine goes into overdrive. Recent events also indicate yet again that many of those working in Australia's mainstream press are themselves short of the necessary scepticism for times like these. This does not mean, however, that we as individuals cannot bring our own sceptical frame of mind to bear on the events as they are unfolding. So let me go to the Human Rights Watch, the approach to investigation. It's not just what we as the populace are told that is the problem. People's homes were searched in those 25 raids, some for many hours. That is a nasty interruption to one's life. One woman was dragged from her bed. Someone else ended up with a black eye. What the authorities do, as well as say, is also of major concern. This concern is underlined by the HRW report, to which I will now turn. The HRW study examined in detail 27 cases of investigations involving American Muslim defendants. The study looked at the cases from initiation of the investigation to sentencing and post-conviction conditions of confinement. The report documents the significant human cost of certain counter-terrorism practices, such as aggressive sting operations and unnecessarily restrictive conditions of confinement. Many of the more than 500 individual prosecutions which have taken place have targeted individuals who were not involved in any form of terrorist activity at the time that the investigation began. In some cases, the FBI may have created terrorists out of law-abiding individuals by conducting sting operations that either facilitated or invented the suspect's willingness to act. The statistics are stunning. Out of the more than 500 federal counter-terrorism convictions, nearly 50% resulted from informant-based cases, and almost 30% of those cases were sting operations in which the informant played an active role in the underlying plot. An example of the sting operation is a prosecution known as the Newburgh Four. A judge in that case said the government came up with the crime, provided the means and removed all relevant obstacles, and in the process had made a terrorist out of a man who was no more than an unfortunate clown. The report found that in 2 cases, law enforcement officers offered money to suspects to entice them to participate in a plot. Let me share with you a couple of examples. An FBI agent told the father of Rezwan Firdaus that his son obviously had mental health problems. Despite being aware of this, the agency targeted Rezwan and sent an informant into his mosque. FBI informant and Firdaus devised a plan to attack the Pentagon and US Capitol, with the FBI providing fake weaponry and funding Firdaus' travel. While this was going on, Firdaus' health was deteriorating badly and he lost large amounts of weight, and so lost his bladder control when he had to wear nappies. He was eventually sentenced to 17 years in prison and another 10 years on parole. My second example is Adel Daoud. Adel was a quiet 17-year-old student when FBI agents started communicating with him through an online Islamic forum. Adel was asking his parents about the meaning of jihad. They told him it was the struggle to be supportive of his parents. Don't a lot of our children need to engage in jihad of that kind? The FBI agents slowly developed a plot online for Adel to attack a bar in downtown Chicago. When he was arrested, the community was shocked that the police had decided to ensnare him rather than warn his parents of his vulnerability and suggestibility. His trial comes up this month. My third example is Ahmed Omar Abu Ali. Abu Ali was swept up in a mass arrest in Saudi Arabia. After being whipped, denied food and threatened with amputation, Abu Ali made a confession to Saudi interrogators, which he has since recanted as false. Despite his claims of torture and a false confession, a judge in Virginia allowed the confession into evidence, and Abu Ali is now serving a life sentence in a super maximum security prison in Colorado. My last example is that of Uzair Parasha. Uzair was kept in solitary confinement for 2 years. After the first 9 months, the government lawyers were offering a plea deal, and Uzair was insisting on going to trial to win his freedom. He was moved to a special regime of solitary confinement, where he was only allowed to talk to guards. All he got to say for months were words and phrases such as, "Thank you for turning out the light," or "Can I have some more toilet paper?" Uzair has since been convicted. In the last 12 months, we've seen the Queensland government borrowing similar harsh conditions in jail as a means of launching a political campaign against a particular group in the community. While Mr Newman has been very forceful in defending the Muslim community against prejudice, there is a danger that another government at state or federal level will use harsh prison conditions as part of an anti-terrorism crusade. That is the end of my examples. And I won't read them out, but Human Rights Watch expressed a number of concerns arising out of their study. Now, those problems, of course, would never happen here, and Australia has every reason to be proud of its criminal law advocates and judges who will ensure that even the most draconian legislation will be subject to great scrutiny during its implementation. However, as that Shiite family dragged out of their beds for a plastic ceremonial sword will tell you, good judges and good lawyers cannot always protect you from bad laws. And it is to one example of those bad laws to which I wish to turn. Special intelligence operations. The Crimes Act 1914 has contained for some years Part 1, capital A, capital B, which deals with controlled operations. The purpose of the sections is to provide for police officers and some other law enforcement officers to be authorised to engage in conduct which might otherwise amount to criminal activity. The statutory purpose of controlled operations is to obtain evidence to allow the prosecution of criminal activity. It envisages that criminal organisations may be infiltrated by undercover officers to obtain such evidence. Police officers and others, including informants who carry out a controlled operation, are exempted from any criminal liability and are indemnified against civil liability. This type of operation is designed to set up sting operations, and the possibility that the undercover officer or informant will cause offences to occur rather than just obtaining evidence is always present. The legislation contains a limited safeguard against this, in that the protected actions must not involve intentionally inducing offences to occur that would not otherwise have occurred. Since there is a great deal of legislation criminalising conduct associated with terrorist acts, controlled operations may be used as a method of counter-terrorism. Despite the fraught nature of undercover activity, one can understand the use of controlled operations by law enforcement bodies like the AFP. This year, the Parliament decided to put ASIO into the controlled operations business. The operations are called Special Intelligence Operations. They are not required to be authorised by a court or a judge, but by the ASIO Minister. I think that's Senator Brandis at the moment. The scope of SIOs is virtually unlimited in that they are only required to assist ASIO in the performance of its special intelligence functions, which, when one looks at the definition, is virtually anything to do with gathering intelligence and passing it on. The legislation contains the same type of limited safeguard, namely that the SIO is not to be conducted in a way that would be likely to induce a person to commit an offence that the person would not otherwise have intended to commit. Of course, that does not prevent sting operations. It does not prevent a person being induced to commit an offence that she was not intending to commit. To show an overreach of power, one would have to show that it was not likely that the person would have intended to commit such an offence. That is pretty hard to prove. The safeguard does not prevent the officers bringing it forward, that is the offence, or assisting its happening, or making sure that it does happen. And of course, authorisation for an SIO means that those engaged in it are indemnified from any criminal or civil liability for their actions in pursuance of the SIO. Now, I am not convinced that the collecting of intelligence should be the subject of exemptions from criminal and civil liability. Intelligence gathering bodies are not law enforcement bodies. The role of intelligence agencies is to listen, watch, analyse and advise. They have many intrusive powers to allow them to carry out those roles. They can use listening devices, they can use tracking devices, they can intercept and inspect postal articles, they can search premises, they can access people's computers, they can force people to attend and be questioned, they can force people to answer those questions on pain of 5 years imprisonment. They can detain people, keep them incommunicado and question them up for 7 days and force them to answer those questions, also on pain of 5 years imprisonment. And they can intercept all kinds of telecommunications. That seems to me a more than adequate set of powers for an intelligence agency to have to carry out their roles without getting into the business of joining criminal organisations and committing criminal offences. But if ASIO is to be given these vaguely defined and unrestrained powers, which include infiltrating organisations that it chooses to target and committing criminal offences, including the planning of terrorist actions, we need as a society to be able to scrutinise in great detail how ASIO uses those powers. We need to be able to provide close scrutiny to prevent overreach and abuse of such powers. Of the many ways in which such powers can be misused, one is carrying out the kind of unethical and unjustified sting operations described in the HRW report. But if you thought that such close scrutiny would be available to save us from overreach and abuse, meet the new Section 35P of the ASIO Act. Section 35P was added to ASIO's powers by the bill passed by the Parliament and assented to on 2 October this year. A person is liable to 5 years imprisonment if she discloses information and that information relates to a special intelligence operation. The mental element to commit that offence is recklessness. A journalist who hears that shady people are trying to talk somebody's mentally disturbed son or daughter into carrying out stupid violent acts is prevented from reporting that information because it might be part of an SIO. If she checks with her contacts and they say, stay away from that, she'll definitely be committing a breach of Section 35P because it definitely might be an SIO. And the more a journalist is a careful reporter and checks her other contacts and sources, the more likely she is to breach the mental element of recklessness, because she is going to receive more and more hints that she should not report the matter, no matter how much the incident cries out for and needs to be reported. And even if it is not an SIO, the journalist can be warned off reporting it. It might be a bunch of AFP officers setting up a stupid sting operation of some mentally disturbed and vulnerable person. Section 35P does not apply to them, but they can warn the journalist off simply by saying, you better not report that, because the journalist will not know whether ASIO is involved or not. And the journalist could easily get 10 years instead of 5 years if she goes ahead and reports, because 10 years maximum is applicable if the disclosure will prejudice the effective conduct of an SIO. So it might be an unreasonable and unethical sting operation. It may involve people having been assaulted or threatened. It might deserve to fail. That won't matter. If the disclosure has the effect of prejudicing the success of the operation, the 10-year maximum will apply. Section 35P will put a freeze on effective scrutiny by the media of the actions of ASIO. As I have explained, it may also prejudice effective scrutiny of law enforcement bodies acting in the same space as ASIO. We know from past incidents that ASIO deserves to be scrutinised, as does any intelligence gathering organisation that is authorised to act secretly. Section 35P is a threat to our freedoms and to the effectiveness of our media organisations. I am concerned, therefore, that the types of injustices reported by HRW are more likely to occur here in Australia in future years than they were likely to occur in the past. Let me finish. I have looked at events from the UK, the US and Australia. The lessons I seek to draw is that we have to be sceptical and we have to take a critical look at everything that is served up to us as part of a national security agenda. The lessons from the recent past is that much injustice can occur in the name of protecting national security. And we have to be aware that our natural allies in scepticism are sometimes unwilling or unable to assist, and that their ability to assist us is being taken from them. Accordingly, it falls to every one of us to become informed and provide the scrutiny and scepticism that our society badly needs. Thank you.